Yo, what's up, y'all? So listen, y'all know we got a doozy of a story today, man. Listen, this Young Trugs trial, I was wrong, okay? I was wrong 2 years ago when this started. This is gonna end in a mistrial. I've never heard of anything like this ever in my life. The allegations that you're about to hear, well, it's not even allegations anymore. It's an affirmative fact that they did have this meeting, and I'm gonna show you that towards the end of this video. But I'm gonna walk you through all these clips, especially if you haven't seen them. I'm gonna walk you through them. We're gonna go through them. We're gonna talk about it. And yeah, man, if you're enjoying what I'm doing here, you know what I'm saying. You like the content, you like the channel, you like me. You know what I'm saying. Go on, like, comment, and subscribe. You know what I'm saying. Anyway, let's get to it.
That for purposes of it. Well, I'm going forward. What I was told was that Mr. Copeland said, and you haven't answered my question yet. I'm not. I didn't answer that question. No, I will not answer that. Why will you not answer that question? Because I want to make sure that what I say is accurate. I'm not trying to. No. I'm asking you, how did you get this information? I'm not telling the court. What I'm saying is based on information. Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems. I have problems right now. Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean, a witness who was sworn in Friday, the court's telling, this is what I was told. If this is not true, not true. This court asked me, tell me how you got the information. Listen, tell me what you tell me how you got the information, then we can go ahead and go forward. I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court. It concerns me that you have proprietary information. Why is it proprietary? Information that you should not be having, that was ex parte. Why? With a party. Why? State of Georgia. How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly that's this honorable court, excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but what I did. Mr. Steele, I still want to know, how did you come upon this information? Who told you? What I want to know is, why wasn't I there? Why I'm going to hold you in contempt if you don't tell me who this. Tell me who this information is. I don't want to be held in contempt. Well, then answer that question. That's attorney-client privilege information. I am not attorney-client privilege unless you were in my chambers. That's the only way you can figure out. I tell you what, I'm going to give you 5 minutes. If you don't tell me who it is, I'm going to put you. I'm going to put you in contempt, because that is not attorney-client privilege. Attorney work product privilege. How did you get that information supposedly from my chambers? Did somebody tell you? You should have told me. You got 5 minutes. Well, you don't need it. I'm going to continue. This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas. Don't take my notes. No.
Woo. Okay. Listen, let me oh God, let me get the next clip on the screen. Let me get the next clip on the screen so I can make sure we're gonna proceed forward from here. Okay. I want to make sure we're gonna proceed forward. So listen, let me hit this, but it still does the same thing bad. So look, if you weren't able to follow, this is what happened. The judge, the prosecution, and a witness that wasn't cooperative, okay, wasn't being cooperative, had a meeting on the side. Before, and I mean, like, not before, but without the defense counsel present. That is illegal. That is illegal. The defense counsel needs to be there to make sure that nobody's being coerced into different situations. So they're trying to figure out who told him. Like, the judge is more concerned, instead of being concerned that, okay, yeah, we did this wrong thing and y'all should have been present. He's like, nah, just tell me who told you. Tell me who told you. Because he feels bad, because he's like, man, what else they gonna tell? You know what I'm saying? Like, yeah, he's trying to end the trial. He's trying to slam dunk it. You know what I'm saying? But they're not. The state of Georgia, they know they're losing this case. There's no reason this should take 2 years. Doug had been in jail for 2 whole years. I didn't even realize it'd been that long. He'd been in jail this whole time, like without bail. Like, at least let him go home and show up to court every day. He can't even make more money. That's why he had to call in that favor for Drake, for 2 Drake verses, because he didn't have it. He didn't have it. So I don't know what's going on, bro. Like, I listen. This is wrong. The state of Georgia, this is gonna be a mistrial for Young Thug. Let's get into this next clip, because man, when he came back from recess, yo, this is where it got completely out of pocket.
All right, Mr. Steele, before I recess, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again, and I respect that. And it gives me no joy, as you know, Georgia Rule Professional Conduct. Please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6. I know what the rule says, but here's the thing. Well, I'm just, but in order, you need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt. I understand. I don't want to be held. I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious. Yeah. And that's why I raised it. It is that serious that we should have been there, and it shouldn't have happened. Sir, that's a whole separate issue. And that's why
that's not a separate issue, bro. Those issues go hand in hand. Basically, you can look at this person that told this. Look at the person that told this as a whistleblower. This is technically a whistleblower. Whoever told him, whoever told Thug's team or told somebody around whatever, whoever told it did the right thing, because you know it's wrong. You're not even arguing that the merits of what you did was wrong. You're not even arguing that, which is crazy.
That's why ex parte conversations are recorded. Why would it be ex parte? It's ex parte under the deal. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation. I've never asked this honorable court or any court to meet with me and a witness. Sir, you're straying off the issue. I'm not. The issue is how did you get this information? Conversation. I've never asked this honorable court or any court to meet with me and a witness.
No. Look at right here. Look at right here. I hate to get psychoanalytical and like kind of ruin the video, but look at what he does. Look at what he does. Look at what he does when he says that.
I've never asked this honorable court or any court to meet with me and a witness.
Look, he's looking off. He can't even look at the man dead in the face because he know he's fucking wrong. He know he's dead ass wrong. Notice when he's saying everything else, he can look the lawyer dead in the face. And many of the other times when he's talking, we just watched him earlier, and you're going to see in the rest of this clip, he has no problem looking him dead in the face. But for some reason, this point, he couldn't look him in the face. Why is that? Because you know you're wrong.
Sir, you're straying off the issue. I'm not. The issue is How did you get this information? I understand the issue. I promise you I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law. You can't violate something and then use privilege. Okay? I'm not violating anything. Okay, but that's why I'm saying, how did you get their information? But just listen to what I'm trying to tell you. You're saying the privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't. Let me tell you. I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe. You're asking me, I'm not saying you're ordering, but to give you information, and you're saying it's not some substance, but I'm telling you, I can't do that under the bar rule. All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you some in substance of what was said. I asked you how you got it. You can't do that. Yes, you can, because I have an idea how you got it. Your idea. I have an idea how you got it, but that's improper. Sir. Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not sure. I don't want to hold you in contempt, but this is that serious. Judge, you cannot eavesdrop and get information that was not meant for you to hear at that particular point in time. Judge, listen. I'll do whatever you want at 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing. I'm moving for a mistrial. It is my understanding, based upon information belief, from whom? Part of it. From whom? Well, I'd like to get the substance first, and then we'll keep talking. Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So, but you're assuming something because I told you already. Well, then, other than if you were sitting, unless you were sitting in there with a recorder or Miss Love or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left. Well, Your Honor. And if that person gave you that information or shared that information with you, she probably violated privilege. Well, let me tell you 2 things. One, I don't know how that was a privileged communication. It shouldn't have been. Well, because she has a client she's supposed to represent. Who are you talking about? But anyways, I'm not going to have I got this information. I'm not going to have any further conversation with you about this. I want to know, the question still remains. I want to know who gave you the information.
Okay. All right, let's go over it so far. Let's make sure we're tracking, okay? So the person, and I want to make this clear for y'all, okay? I want to make this clear for y'all because I tried my best to shut the fuck up. All right, so listen. The conversation that the person that he's alluding shared the information is the previous, for the witness that was there, attorney, right? The witness's attorney was only there and hired for 1 day, just 1 day, and then they were subsequently fired by the witness, because the witness, they were only there to represent during like this weird meeting or whatever the fuck it was, like that they were supposed to have, or like that one trial day when they were a witness just to represent them then, and then that's it. They were a 1 day attorney. That's all they were hired for, was 1 day, right? So he's alluding that attorney, that woman, gave him the information, but he has no way to confirm how he got the information, especially if they were smart about it and just talked in person. Because if you end up meeting with somebody in person and you just talk, like, how the fuck they gonna prove it? Like, how the fuck they gonna prove it? How they gonna prove it? They'd have to like do like some deep investigation, which they don't have the time to do during this trial to find out. My whole thing is this: By the time the judge finds this shit out, he's probably going to be disbarred. He's probably going to be removed from the bench. Just straight up. He's probably going to be removed from the bench because the substance thereof is wrong. What he did was wrong. But what the lawyer did was also, if it was the lawyer, was technically wrong because it's our ex parte conversation and the other people weren't privileged to it, and it should have been given to all the defense attorneys at the same time. However, I will say, like, all the rest of the defense attorneys are looking like, yo, what the, and even another one ends up coming up in his defense.
I'd like to know what information happened outside of this. That really is. You can go into custody. The court needs to again declare a mistrial based upon. Okay, and I'm going to deny your motion. I'm going to deny your motion. I understand that you spoke with a witness outside of our presence. And whenever, yes, I had an ex parte conversation, which is appropriate, and you influenced the witness based on information belief, and I'd like to have that all on the record. All right. I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been. Because you got some information that you shouldn't have gotten. Why? Well, we can, that's for another day. But why? Okay, that's for another day. In the first place, I didn't know about this stuff. That's for another day. So I raised it as soon as we found out about it. Well, I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2. Okay. That is a material or critical part of the case, and it's an automatic reversal. Mr. Steele. But you're acting like it's Mr. Steele. That is not when that is not the case when somebody discloses information in a ex parte conversation that the one.
So look, he keeps dancing around it. The judge doesn't address any of the substance. Notice, he doesn't address any of the substance of what the lawyer says. He keeps going back to, well, this would only be valid if it wasn't ex parte. You know what I'm saying? But since you got the information, bad information, a bad way, you can't use it against me. Like, what? That's okay. Look, that's like which for some reason, I have a funny feeling like the example I'm going to use would hold up in court, which is kind of like insane, right? Which is kind of like insane. Like, let's say the way you got the footage, right? That somebody robbed you, right? Like the only way you got it was that you stole the footage from somewhere, right? You stole the footage, right? Or no, you didn't steal the footage. Somebody else stole the footage and gave it to you. And then the court goes, hey, you shouldn't have this footage because somebody stole it. Who gives a fuck if somebody stole it and gave it to me? I have the footage now. This proves this person actually fucking did it. They robbed me in 4K. And the court is supposed to turn that like, that's the level of logic. That's what he's going for. And I'm like, that don't make sense to me. If this is our justice system, we're fucked. We're fucked as regular people. Young Thug got money. He got other people that got money. As regular people, we ain't got that.
The party's lawfully asking the whole. You're not supposed to have communication with a witness who's been sworn. I'm not telling you. I'm just saying, if you read the case, I'm assuming you read it. That's what it says. And you did it. The statement should be heard. You said it supposedly. And what I'm trying to get to is, why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we can really understand it. And then anything that was not on the transcript, if anything, then we understand what happened outside our presence. Okay. And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something. I don't think you're breaching 1.6. You can't hide behind 1.6. I didn't hide it. You can't hide behind it. But the thing is, I think you got this information.
I think
somebody disclosed it to you, and that's the only way you could have gotten it. Yeah, unless you're sitting there unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or the didn't give you the information. So, Your Honor, that's the issue, isn't it? Well, that needs to be told. But we don't know why we were excluded from it. Mr. Steele, I want that information. Mr. Williams' constitutional right, the Georgia Constitution. Just stop at this point in time, because Article 1, because you already said that. You already said it was the Constitution, and we have the right to be present. All right, Mr. We're not waiving any. Yes, ma'am. Well.
Yeah, that's insane. That's insane. That whole sequence is insane. I've seen a lot of shit in my life, y'all. I've seen a lot of shit in my life. I ain't never seen no shit like this ever. So here's what happened after this. Sorry, this video took so long, but hey, it is what it is. Like, look, I gotta get you all the information. I gotta get you all of it. So look, Attorney Steele, okay, the guy that was talking, Brian Steele, he ended up getting arrested, like held in contempt, got arrested, got booked into jail, whatever the hell happened, right? His wife, all right, his wife, all right, all right, is going to represent him in his appeal. Notice is hereby given that Brian Steele hereby appeals to the Court of Appeals of Georgia from the order of contempt on June 10th, 2024, holding Brian Steele in criminal contempt. The clerk will kindly take note that the transcript of evidence of the proceedings on June 10th are to be included with the record on appeal. No other portion of the record is to be included for this appeal. The Court of Appeals of Georgia has jurisdiction of this case on appeal this 10th day of June 2024. And that's his wife. So he's appealed the decision to the appeals court. What does that mean? All right, what does that mean? All right, look, I'm not a lawyer, but I did read some stuff. All right, so what that means is, okay, they could overturn the contempt just off rip. They could overturn the contempt off rip. They could just go, oh, we're going to overturn the contempt. They could even go further to go, hey, and admonish the judge and go, hey, there's something foul going on here. You know what I'm saying? And that could go numerous ways. Once this gets held by heard by the Court of Appeal, this could go a lot of ways. This could give the mistrial. This could give the mistrial. The judge might have overstepped his bounds here. He might have overstepped by doing his contempt. He might have overstepped. But that's what could happen. That's what could happen. This could get it thrown out. All right. Now, here we go. Now, we got even more, okay? We got even more evidence of stuff going awry. We got my boy, what the fuck is his name? Lawyers for Workers. I believe that's what his page is called, Lawyers for Workers. Last time I seen dude was during like the Tory Lanez trial stuff. Yeah, I did have coverage up on my channel of that, but I got rid of it all. Well, most of it. I got rid of most of it, not all of it, just most, because one of them was a podcast episode. So if you want to see a piece of it, you can go back there. But anyway, let's go.
I'm going to play for you a clip from the YSL trial. Listen and watch. I don't think anybody saw this. When the defense team sees this, they need to put this on the record in court tomorrow.
Yeah. All right, let's take 10 minutes and then we'll see where we are. See where it leads us. All right.
Headache. You heard the witness say, I got a headache. You see the court reporter. The court reporter is standing there. She's not writing the stuff down. They are not on the record. This is not live court at this point. Everybody's on a break. They're just standing, waiting for the jury to leave. Nobody should be talking to the witness. But the prosecutor is doing all this, and then the witness says this. Listen.
I'm not gonna take the fifth.
Okay, you just heard that witness say, I'm about to take the fifth. And I have a couple of questions about why he said that. That was an off the record statement. The reporter was not writing down what people were saying because they were on their way to a break and everybody's simply exiting the courtroom. Certainly nobody should be having a conversation with the witness. If the prosecutor goes up, has this extended communication with the witness, at the conclusion of which the witness says, I'm about to take the fifth, that's alarming. That sets off a flag. If you were the judge, you might want to ask the prosecutor what she just.
Yeah. You might want to ask the prosecutor what she was talking about, what she just said. If you want to go see more, go check out Lawyers for Workers on that. You know what I'm saying? I believe he has a YouTube channel for now. But yeah, there was a lot of stuff going on there. Inappropriate conversations. Those conversations really shouldn't have happened. Like you can't talk to the witness without, because here's the thing. The defense attorneys could be already out the door when the prosecution walked up there. And nothing's being recorded. Again, that goes back to this ex parte thing. They're blatantly doing this stuff. This is bad. And this is why I'm totally against it, because if I was on trial, I don't want none of these shenanigans going on. I want a fair shot. I can't get a fair shot when y'all are communicating off the record and doing things off the books and doing extra things to get me into jail. Like, every American should be concerned about this, especially Georgians. Y'all should be really concerned about this. Y'all should be raising the alarm, not to defend the Young Thug, but to defend your rights in the event that you end up in court. That is what you're defending, not Young Thug. You're defending your rights. Your rights. Anyway, I got one last thing, and I'm finna get up out of here, man. So listen. Let's zoom in. Let me zoom in a little bit. All right. I'm gonna read this. All right. So this is State of Georgia versus Caleb Adams order to show cause. Yes, this is the attorney. This is the attorney. Okay, this was filed today. This is the attorney he was talking about. This is the woman that only represented the witness for one day, Kenneth Copeland. All right, she was only representing him for one day. All right, so listen. The court, having been presented with an issue of contempt for determination all individuals that were present for the ex parte conversation that took place in the court's chamber on the morning of June 10th, to include witness Mr. Kenneth Copeland, his attorney, Ms. Kayla Bumpus, and all representatives of the state and court security personnel that were in attendance, are hereby ordered to show cause before the Honorable Ural Glanville on the 25th day of June at 9 p.m. At 9 a.m. in the courtroom 1C, 185 Central Avenue, Southwest, Atlanta, Georgia. Why one or more of them should not be held in this contempt for disclosing information from the ex parte conversation to members of the defense counsel. It is further ordered that failure of any individual who was present for June 10th ex parte conversations will cause the court to direct the Boone County Sheriff's Office to take them into custody and bring them to the bar of this court. So ordered, the 11th day of June 2024. All right, so that's what's going on here. So he's trying to shake the tree. He's trying to rattle the cage, and you know what I'm saying, try and like get to the bottom of this. Like, who's leaking my information? Who would tell on me? You know what I'm saying? I'm the judge. I'm all powerful. No, fam. You fucked up. Okay, you fucked up. You got caught in 4K. Everybody around, and this is why I love that Georgia court's televised. Everybody's seeing this and going, that's not right. Everybody's saying that's not right. Everybody. A lot of lawyers are chiming in going, I wouldn't want that to happen to my client. You know what I mean? Like, because it's unfair. It's literally unfair. And the lawyer read the rule, And the thing is, the judge didn't even argue against the substance of the conversation or the conversation in general. He was just like, I can't. How'd you find that out? How'd you find out? How'd you find out? How'd you find out? Oh my God, how'd you find out? Oh, no, I'm going to hold you in contempt. Tell me who said it. Oh, shut up. Oh, shut up. Shut up, bro. Free Young Thug, bro. Free Young Thug, bro. I'm on Young Thug's side now. He getting violated. His rights getting violated. He's right getting violated. Even if 10% of what they have him accused of is true, free Young Thug anyway. Because at the end of the day, his rights have been violated in this trial. And so have the rights of all the other individuals in this trial. And the state did wrong. And I want not just a mistrial. Like, I would love to see this just dismissed with prejudice. Like, get rid of the judge and all of that, man. Anyway, I'm up out of here. Y'all have a good one. If you made it to this point in the video, you might as well go and subscribe. Go and lock in with your boy. Go and lock in with your boy. Anyway, I'm up out of here. Peace.